We now have Ordinance C-34760. We have some folks signed up. We will start off with taking that testimony, and then we will make some decisions after that. So, again, a lot of you have been here before. If you intend to say the same thing somebody in front of you is saying, please reconsider, but you're welcome to speak. So we have Ed Burns, Rick Bocook, George McGrath.
Good evening, council members. I'm Dr. Ed Burns. Thank you very much for the actions you took a couple weeks ago to get to the point where you can make a decision about appealing this to the Superior Court. From the materials that you had provided, it appears like that's a viable option, or at least an option you're going to consider. I have to tell you, I've told everybody that I can get to listen to me that you acted with very good faith last time in seeking additional counsel. And I really hope you continue to act with good faith with us, your constituents, in moving this forward to an appeal, to appeal the decision of the arbitrator rather than to repeal the ordinance.
Thank you. Mr. Bocook, Mr. McGrath, Marianne Torres.
I just want to say that I still feel it's really necessary that you appeal this decision because I get direct witness of things that I don't really like to see. I see abuse of innocent people right in front of my very eyes, and I do, you know, see now Bob said I can't say I work with the Ombudsman. I don't know what you call it, but I do engage with the Ombudsman about a lot of these things, and I think that he has come quite a ways in the things that he does. I don't know why they have to have a fear of him, but but I think he's having an effect, and I think that he should still have his authority, because there's been a lot of things that are in the papers and the news, and I don't say it's about all of them, but it's about enough of them that it creates a mistrust, and I see the mistrust downtown a lot with a lot of people that that there's people that don't have jobs down there, and I don't care what anybody says about me, I still work with these people to try to get them to control their anger, and so that's about all I have to say right now.
Thank you, Mr. McGrath, Marianne Torres, and Michael Powlin.
Council President, Council members, George McGrath. The powers that the police ombudsman were given by you as a city council were a good start, a far cry from what the city council or what the ombudsman's office should have as far as powers. However, apparently this ran counter to the police guild. So what we have is the foxes still wanting to guard the hen house with no one else able to say anything. I believe that this definitely should go to appeal, because I do not see how anyone in good conscience could say, well, gee, we can't investigate our police officers, no matter how atrocious their actions are, because it hasn't been negotiated with the guild. I do believe that if this is going to hold true, then let's put together a committee of 3, possibly 5 citizens with all the power and the authority that they can possibly have to investigate any complaints against the police department, and with the authority and the ability to recommend actions, punitive actions, or what have you. Thank you.
Thank you, Marianne Torres, Michael Pollan, Michael Rouse.
Council members, you already know that I'm standing in favor of appeal, and Ed Burns basically spoke my words. I'm asking you to appeal, don't repeal.
Thank you. Michael Poland, Michael Rouse, Buell Hollister.
I'm also asking you to appeal, and I would take this opportunity to encourage transparency in the negotiations currently being conducted with the Police Guild so that we don't end up with the same problem in January of 2012. I'm asking this council to make a special effort to, number one, encourage transparency in the negotiations. I know this is something that doesn't happen and it's behind closed doors. This stuff happens and we're stuck with it. And if you are presented with a contract that doesn't allow for transparency and accountability, as we've been encouraging come January, I asked you to turn it down and take it to an arbitrator rather than accept it that way. And I want to add to the library report, if I may, one of the things I appreciate about the libraries is the public meeting spaces as well. Thank you.
Thank you. Mr. Rouse, Mr. Hollister, Mr. Green.
Let's appeal it.
Thank you for your succinct analysis, Mr. Rouse. Mr. Hollister, Mr. Green, Liz Moore.
Mr. President, council members, ditto.
Thank you for your even more succinct analysis, Mr. Hollister. Mr. Green, and then Liz Moore.
Let's fight for real power for the Ombudsman or some kind of a committee, as Mr. McGrath suggested. Thank you.
Thank you. Liz Moore.
We obviously, Liz Moore from the Peace and Justice Action League, we support appeal as the correct way forward at this point. Thanks.
Mr. Moore, or Ms. Moore, could I ask you a question?
Sure.
If it meant it could not be negotiated in a labor contract, would you also agree?
I don't think I know enough to have an opinion based on that question. Can you tell me a little more?
If it's in litigation, you can't necessarily negotiate it.
That doesn't seem to line up with what was implied from a letter from Mr. Delaney regarding waiting to appeal while negotiations were in place. So I think, actually, I would support appealing. This is my opinion, not something I've discussed with the organization, obviously, in the last 10 seconds. But seeing as the success rate in negotiating with the Guild so far has been 0 on this, I would support appealing it so that there might be some way to move forward.
In negotiations, there's...
Mr. Apple, hold on. Mike?
I would just add that I don't believe there's any prohibition from negotiating while the appeal is going on. The appeal may have ramifications on the negotiations, but it doesn't prohibit the continued negotiations on those topics.
Well, that's debatable. I'll leave it at that.
Okay.
Thanks.
Well, this is what we're going to do. Under special considerations, it's a resolution, actually, 2 items, S1A and B. And what we decide with regard to those will have a very definitive impact on Ordinance C34760. I've deliberately elicited your input since you came down here, but before we vote on Ordinance C34760, I'm going to shift down to special considerations. Terry, S1A and S1B.
S1A, Resolution 2011-79, approving Rochelle L. Wills and the law firm of Littler, Mendelson, PS, a special counsel to represent the city of Spokane in all legal proceedings stemming from the July 11, 2011 arbitrator's opinion and award. S1B, contract with Rochelle L. Wills and the law firm of Littler Medelson PS for special counsel services associated with the appeal stemming from the July 11, 2011 arbitrator's opinion and award.
Mike, in essence, if we pass these in tandem, what course of action is then to be accepted that the council is undertaking?
Well, if you pass the resolution, you will have appointed Rochelle Wills and her firm as special counsel to pursue the action. In this case, it'll be in Superior Court. The second item is approving the contract to pay for her law firm. That action will proceed immediately. That will then bring up the question of the ordinance, whether or not that should then be tabled because the council has taken a course of action that would be opposed or opposite of repealing the ordinance.
Okay.
And could I also just ask the council to have a quick motion to accept the revised version of the resolution and contract? They came back from Rochelle Wills with a couple minor changes. One, just clarifying, putting in the arbitrator's actual name, Michael Beck, and also referring to the type of action, which would be a petition of writ of certiorari filed in Spokane County Superior Court.
So moved.
Second.
All in favor? Aye. Opposed? Thank you. Any comments from the audience of what we're undertaking here? Okay. In essence, if we approve S1, A, and B, we will be appealing to the Superior Court tomorrow. I don't want to hear any shouting, jumping, screaming, or anything else. Steve?
I think it's important for everybody to know that, in my opinion, this action will defer any meaningful opportunity for negotiation. The action could take anywhere from, 6 months to 2 years before the court hears and responds on that. So I think it's important in passing this to realize that we are moving in a direction that would give ultimate authority, but really, in my opinion, greatly challenges our ability to have that as a significant outcome of the bargaining that's currently taking place.
Ms. McLaughlin?
I can't believe that we're actually going to make a decision here tonight. I'm very excited about this, actually, because as many of you know, it always comes down to me with so much of it is how's it going to affect our bottom line. And as much as...
Thank you for the entertainment, Mr. McGrath. Go ahead.
As much as I'm not necessarily pleased that we're going to continue to spend more money on attorneys as we pursue this battle, but I'm more convinced that we shouldn't be spending $200 a year on an ombudsman program that doesn't give the correct amount of authority to that office. I think that's a misuse of our taxpayers' dollars. And, to be real honest, I'm not necessarily optimistic in the turnout of going to, what the outcome will be going to Superior Court. But what I am convinced is that we have to complete this path to be able to get where I think the only true fix is going to come from, which is at the state legislation level. But if and when we have to get there, I don't want legislators at the state level to come back on us and say, well, you had another avenue to go down, you should have done that first. I want to be able to say, no, we've been there, done that, we've spent whatever amount of money it's going to take us to get there, and now it's time for the fix. And to me, the legislation, the state level has authority to decide the scope of bargaining for public employees, and applicable statutory provisions under RCW 41.56 could be amended to specifically exempt bargaining over police oversight programs. And to me, that is where I think we're going to have to ultimately get. But to get there, I think we have to continue to walk down this path. So I am happy to support special considerations A and B tonight.
Mr. Apple?
Well, Steve Corker is absolutely correct. This will delay possibly a year or two any decision, any meaningful decision, and even then it would go back to the PERC board for review. It wouldn't be a win, and we get the arbitrator's decision. The difficulties are also compounded in many ways. If we have a labor negotiation, which is underway virtually with the Guild, and they want to say we have a legal matter that is being discussed, we're not going to discuss that issue, there's a very strong likelihood that that issue would not be discussed because it's a legal matter. So as far as the authority for the ombudsman, it probably could be mute in negotiations. We know that the contracts would probably last 4 years, so you can pretty much estimate the timeline. I was hoping, and I do believe, that most of the council is aware what I found and believed to be the case in August. Now, nearly 2 months later, we're going to have to make a decision tonight because tomorrow is the last opportunity to appeal. And if we don't make a decision tonight, well, we have to repeal. And so here we sit. I want a strong ombudsman. I want an ombudsman who can work with the public, who can do investigations. And this isn't going to happen anytime soon if we appeal. The best course of action, as I see it, is to repeal the previous action. It still leaves the ombudsman in place, and as we have required negotiation with the Guild through the mayor, because the council does not do negotiations with labor, that is done strictly by the mayor as per our Spokane City Charter. And so the openness that somebody mentioned they wanted would have to be through the mayor, and you need to address that. If we don't get it in, or language that would be acceptable, one of two options is possible. No language at all regarding an ombudsman, which then means we are open to the process other cities have used to impose an ombudsman where it's not addressed in the labor contract. Or the alternate option is that it is completely addressed in the language and the conditions we asked for are in place. If either of those occur, who's ever on the council next year when the contract is brought before the council, I would hope would vote yes. Unfortunately, some of us are leaving the council, but I would advise them strongly to vote yes under those conditions. If the language is not what I've expressed, if it does not include the investigative authority for an ombudsman, I would hope the council next year would vote against the labor contract, in which case I think it would force it to binding arbitration. And I think in binding arbitration, the city council, not having been a party to the negotiations, because we're not, we would probably prevail in having that language placed in the contract through forced negotiation. I guess that's just my opinion. That's what it was in August. That's what it is now. And I think that based upon that, I think everybody here now fully understands what's at stake. So I think those who really want a strong ombudsman and do not want to wait years for a chance realize that the best option is to repeal what we have and proceed forward in a responsible manner.
Mr. Rush?
As we've heard from Councilwoman McLaughlin and Councilmember Apple, this is a hard choice. The path is fraught with trouble either way we go. Essentially, if we choose to appeal to Superior Court, we've got to get it in by tomorrow. It will be a lengthy process. And if we prevail at Superior Court, all we really get is a set-aside of the arbitrator's decision, and then we will be back before PERC with, again, what is the scope of authority, what is the statutory requirement here. So that's a long slog. Conversely, the path Councilman Apple laid out, we could back off, repeal the ordinance, seek again to get this negotiated and part of a labor contract, and that's been iffy too. It hasn't happened yet, and I'm afraid that Councilman Apple's assertion that we would prevail at arbitration is speculation. That path is just as fraught with trouble as much as appealing. I guess where I'm coming down on this is that if we appeal, we control our own destiny. and we lay out the path that Councilwoman McLaughlin said. We've made our case, we do our due diligence, we exhaust remedies, and if at the end we do not get the ombudsman authority we're seeking, we can go to the legislature, and we've got a rock-solid case to make changes that will allow us to have that oversight legally. I just don't want to get anybody's hopes up about any resolution anytime soon, but just to slog through the process as we've outlined is the best we can do right now. So I'll support the motion to appeal.